Let's take a look at FMLA qualifying events. An employee who is otherwise eligible for FMLA leave must still experience a qualifying event to be entitled to take the leave. Qualifying events include the birth of a child of an employee, placement of the child of the employee by adoption or foster care, the need for the care of a spouse, child, or parent with a serious health condition, the inability to work due to a serious health condition, the need to care for a service member, and any qualifying emergency due to a family member on active duty. FMLA does not include time off for other family-related activities, such as attending parent-teacher conferences or obtaining counseling for marital problems. Both males and females are entitled to parental leave. Entitlement to parental leave under the FMLA generally expires 12 months from the date of birth, adoption, or foster care placement. If an expectant mother's medical condition warrants that leave begin before the birth of a child, such leave is available under the qualifying event of a serious health condition. The definition of a serious health condition is complex. The term is far more inclusive than disability, but it still does not encompass all medical problems of an employee or a family member. Basically, a serious health condition is a medical condition that involves either inpatient care in a hospital or continuing treatment by a healthcare provider. A serious health condition involving inpatient care includes not only the actual period of hospitalization, but also any period of incapacity and time needed for subsequent treatment of the condition. Serious health conditions involving continuing treatment by a healthcare provider include the following: conditions that result in periods of incapacity of more than 3 consecutive calendar days and either 2 or more treatments by a healthcare provider. Any periods of incapacity relating to pregnancy or prenatal care. Any periods of incapacity, including subsequent treatment due to chronic, serious health conditions for which at least 2 visits to a healthcare provider are made per year. Long periods of incapacity due to conditions for which treatment may not be effective. Any absences to receive treatments from healthcare providers for conditions that would likely result in periods of incapacity of more than 3 consecutive calendar days if left untreated. Ordinarily, unless complications arise, the common cold, the flu, upset stomach, headaches, and other migraines or potential diseases do not meet the definition of serious health condition and do not qualify for FMLA leave. Although these are useful examples, ultimately the criteria to determine the existence of a serious health condition can be confusing. Not surprisingly, the existence of a serious health condition is sometimes disputed and must be decided by a court. The right to take leave for a serious health condition of a family member is limited to immediate family. Employers are not required to grant leave so that employees can provide care to grandparents, aunts, uncles, or even in-laws. A person taking leave based on a serious health condition of a family member must actually provide physical or psychological care. Employers may require that requests for leave based on serious health conditions be supported by certifications from healthcare providers. Employees must be given at least 15 days to obtain this medical documentation. The process of documenting a serious health condition should not be onerous, and the information provided by an employee's own doctor should generally be sufficient. When the information provided is deemed inadequate, employers are required to notify the employee in writing, indicate which information is missing, and afford the employee at least 7 calendar days to provide the information. Employers may contact employees while they're on leave to receive information on their status and verify their intent to return to work following the leave. Employers are also permitted to require medical certification of fitness upon an employee's return to work, provided that this is the employer's general practice. An employer violated the FMLA when it overruled a doctor's assessment that an employee with several fingers splinted could nonetheless perform her job, which included typing without restriction. It is the job of the healthcare provider and not the employer to determine whether the employee is fit to return to work.